It gives you a timer right here.
So this is going to be part 2 of our video review for exam number 3. So we're talking about capacity, and we talked about minors generally being unable to enter contracts. They can, however, ratify the contract after they are an adult. So once they turn 18, they can ratify it either expressly by specifically saying, I intend to honor this contract, or through implication by honoring the contract for a period of time. We also talked about mental capacity and how that affected, that it would be void if you were adjudicated insane, that it would be voidable if you had some mental disease or defect, but you did not understand the terms of the contract. But if you had a mental disease or defect but understood the terms of the contract, it would be a valid contract. Same thing for intoxication. And ooh, do I love a good intoxication story. Don't listen to that, Molly. It doesn't apply to you. You can't drink till you're 35. That goes with dating too. 32 to date, 35 to marry, 32 to date, 35 to drink, 35 to get married. No kids until I'm dead. I don't want any grandkids. Yeah, I've already got gray hair. I don't need any grandkids to push that. Anyway, intoxicated. If you are habitually drunk, adjudicated drunkard, void contract. If you are drunk and don't understand the terms of the contract, it is a voidable agreement. If you are drunk but understand it, it is a valid agreement. And again, who can void it? In a voidable situation, whoever had that impairment. Legality, we talked about what subject matter of contracts are good. We said a contract for a tort or for a crime is not valid. Please don't snap that though, honey. It's recording. She's snapping slimes. Kids with slime these days, it's all over my house. All over my house. I could beat her. But we couldn't enter a contract to beat her because that would be illegal. Trust me, I've looked into it. Anyway, a contract for a tort or a crime is an illegal contract. If you see a contract that was entered into to rob a bank or to commit an assault or a trespass, it's not a legal contract. The next, you're shaking on my Diet Coke. Man, kids. The next thing is a licensing requirement. If the activity requires a license, like practicing law, honey, please don't snap that. Jeez. I'm going to have to beat her. On camera, no less. If it requires licensing and you don't have a license, it can't be a valid contract. Also, usury. Charging a too much interest rate is not a valid contract. Gambling, also not a valid contract. So when I bet Mikey Sims $1,000 that Jim Williams wouldn't get married, that is not an enforceable contract. That gambling makes it illegal. I'll still probably pay him if the dumbass actually gets married. I hope he doesn't. I hope for his wife's sake he doesn't. Anyway, again, unconscionable agreement, an agreement that is unconscionable. If it's fundamentally unfair, still going to be an illegal contract. Another one we talked about is exculpatory clauses. So a clause that absolves tort liability generally is not going to be any good. Did you get slime in my carpet?
No.
Oh my Lord.
I didn't.
She did. Don't let her lie to you.
Look on the carpet.
Bullshit. She did.
I didn't.
Okay. Exculpatory clauses generally are not any good. They are good for an inherently dangerous recreational activity like skiing, like skydiving.
Skydiving.
You know, she just wants to be beaten. She just wants it. She's begging for it. Something inherently dangerous that's a recreational activity. Again, any illegal contract is void, and a void contract means both sides get their consideration back. Again, we talked about a severability clause, that says if one part of the contract is void, it does not void the rest. Otherwise, if one part's void, the whole contract is void. The next thing we talked about was assent and things that in contracts that had to be in writing. So assent, again, means that there's some type of defense of contract is a good way to think of it. One was a mistake. Again, a unilateral, I'll get it right this time. Unilateral is one-way mistake. I make a mistake, but the other side of the party does not. Usually does not make a void contract. Usually it's still a valid contract. It wouldn't be void, it'd be voidable anyway. A bilateral is both sides make a mistake. If both sides make a mistake, it is a voidable contract. Either side might void it. Then we talked about misrepresentation. We talked about innocent misrepresentation, which just creates a voidable contract. Then we also talked about negligent or fraudulent misrepresentation. The example I gave here again was an antique piano. And the question was, did they intentionally misrepresent the age? Or was it negligent, or was it just an innocent one? And the importance of negligence or fraudulent is then we get tortious damages. So we're back to our damages on torts, where there's a lot more money damages. Another, we talked about undue influence. The example I gave here was my mother at Thanksgiving dinner convincing me to buy her house for more money than it's worth and allow her to live in it for her whole life. Someplace where there's a dominant and a submissive relationship, and the dominant person is using their position of dominance to either guilt or somehow make the other person submit to an otherwise not good contract. Then we talked about duress. Duress was either some threat of force, some threat of criminal charges, or some threat to economic interest. Could all be duress. And again, here we talk about unconscionability, and that unconscionability is going to be throughout the whole thing of contracts. Anytime you see something is unconscionable, so fundamentally unfair, the law is not going to make it a valid contract. The next thing we talked about was contracts that had to be in writing, the statute of frauds. And again, we talked about ones that must be performed, that could not be performed within 1 year. And again, we said could not possibly, no way conceivably can be performed within 1 year. Then the contract must be in writing. So like an 18-month lease would have to be in writing. But notice how a lifetime employment contract would not necessarily violate that, because you may not make it 12 months. Could be completed in 12 months. May not be, but it's possible that it could. Likewise, likeliness is on, it doesn't matter. So building a $50 billion building, that'd be a hell of a building, that is anticipated taking 5 years, doesn't mean it's impossible to build it in one. So it could be still completed within 1 year. If it's completely impossible. The next one is consideration in marriage. Again, a valid contract. So somebody comes to me and says they'll give me 20 acres of land and 2 goats for Molly's hand in marriage. I'd rather get a monkey, but...
You already said that in the last one.
I know I said that in the last one, but what's the matter? A guy can't like a monkey? Okay, I'll take the goats. I'm not getting any better offers because
monkeys are cuter.
Because she's a smart ass.
Monkeys are cuter.
Monkeys are cuter, but I'll take the goats because she's a smart ass. Anyway, consideration marriage. Good contract must be in writing. Agreements to pay the debts of another. Think of somebody co-signing. Needs to be in writing. Interest in land, deeds, mortgage, land contracts. Anything that transfers some interest in real estate has to be in writing. And then the sale of goods more than $500. So if you see something for the sale of goods for more than $500, it has to be in writing. If these agreements aren't in writing, it creates a voidable contract. Again, not a void, a voidable contract. The requirements of the writing must identify the parties, must identify the subject matter, must identify the consideration, has to adequately describe the terms so that we know what we're talking about, and has to be signed by the person which you're seeking to enforce it against. Doesn't have to be signed by both parties, just the person you're seeking to enforce it against. Then we talked about the parole evidence rule. And what the parole evidence rule generally said again was that if the contract is clear on its face, if you read it and it makes perfect sense, that's what it means. And there were some exceptions to that, things like to make it void, such as I used the example of I read about a contract for companionship, and then we come into court and I say, well, it wasn't really companionship, that's just the way we wrote it up, it was really for sex, which would make it illegal. And morally wrong, Molly. Gotta keep her straight. Somebody's got to. Otherwise I'll never get my 2 goats and land. I want it in writing though. So there are some exceptions to the parole evidence rule, but generally speaking, if the contract's clear in its face, it's going to be valid. The last section we talked about were twofold. Was the assignment of contracts, the rights of third parties in contracts. So the assignments of contracts, when can you assign a contract to another person? And third-party beneficiary contracts. So what a third-party beneficiary contract is, again, is when 2 parties enter into a contract for the benefit for a third. So if I say my elderly neighbor is having a problem cutting her grass, I will hire a student and pay them $20 a week to come and cut my neighbor's grass. Any one of the three people can seek to enforce that contract. Me, my 80-year-old neighbor, or the student. And they can, the student can sue me for the $20. The 80-year-old neighbor could sue me or the student for a failure for them to pay it, or failure for them to cut it. So third-party beneficiary contracts. Then we talked about discharge of contracts and how contracts are discharged, either by performance. You perform under the contract and it becomes an executed contract, if you remember executed and executory contracts. The failure of a consideration. So if there's some condition, such as I'm looking at buying a plane and I put a condition on it of it has to pass an inspection by my mechanic. If it fails that consideration, it discharges the contract. A mutual breach, if both sides breach the contract, then it discharges both parties. Or by an agreement, if you release each other by the contract. Contracts can also be discharged by law, things like bankruptcy. Somebody files for Chapter 7 or Chapter 11, Chapter 12, Chapter 13 bankruptcy protection. That will discharge the rights of the contract. Tolling of the statute of limitations. Again, statute of limitations is anytime time passes within the time that you can enforce a contract. So contracts in Wisconsin, if there's a breach of contract, you have 6 years to, depending on the contract, 6 years to bring the action. If you don't bring it within that, you can no longer do it. Impossible performance, something happens that makes performing the contract impossible, or frustration of purpose. The purpose of the contract no longer exists, so that we're not going to have the contract be valid. The last thing we talked about were remedies, and we talked about different ways of remedying. Monetary damages, money that you lost, and that could be compensatory or consequential damages. So compensatory is to make you whole. Again, like consequential are other type of other collateral losses that you might have. Again, think about, I contracted with my neighbor to buy his car. I was supposed to get it on Monday. Monday, he doesn't give me the car. I gave him $500. Not only could I cover my $500, but if I missed an important meeting that cost me $5,000, I could potentially sue him for $5,000 as consequential damages. Punitive damages, we talked a little bit about that. Generally speaking, those aren't available in contracts, but they are for fraudulent situation or an egregious situation. We talked about liquidated damages, which would be a damages amount that's agreed upon in the contract. So if the contract says upon breach, the party shall pay $500,000 in damages, that is what the damages are. The last one we talked about was specific performance. And what specific performance is getting an order from the court for the person to do the action they're supposed to do. So what this is I agree to buy my car, or I agree to buy my neighbor's car for $500. I give him the $500. He refuses to give me the car. Specific performance for me would be me to go to the court and say, Judge, order that I own that car. And the judge can enter an order requiring him to turn over the car to me. And if he doesn't, then it's power of contempt and could potentially sit in jail. The last thing we talked about is duty to mitigate damages. And what a duty to mitigate damages are is anytime you're involved in a contract, you have a duty to try to mitigate your damage, lessen your damages as best you can prior to bringing in action. Classic example here is, again, I agree to buy my car for my neighbor's car for $500 because I have an important job interview. I give my neighbor the $500. He refuses to give me the car. I sue for my $500 back, plus that I've lost $1 million job. He could bring up and say, you didn't limit your damage, Jeff. Why didn't you take an Uber car over to your interview? And that could have saved you a lot less damages. So in contracts, you have a duty to limit your damages. And that's unique to contracts. We did not talk about that in torts at all because it does not exist. So, but under contracts, you have a duty to mitigate your damages. That's all I have for the review. If you have questions, give me a call, send me an email, send me a Snapchat. I'm around. I'll help you however I can. I'm around this weekend too, so text me, call me. I'm around, and good luck. And hopefully this helped, and hopefully the audio is a little better because I did get myself this fancy dancy little lapel mic. You couldn't even see it with my black sweatshirt, could you? So hopefully the audio's a little better, and hopefully you enjoyed the video. And Molly, thank you for helping. Come in and say hi. Come on.
No.
Come on, or no
But do
cookies.
you like the background?
Come in or no cookies.
I'm gonna
Say
cut
hi.
this part.
Okay, that's all we have. Good luck, and I'll see you guys on Monday. Okay.
What if they're not in your Monday class?
Or if you're not in my Monday class, or Wednesday night. I told you she was a smart ass. Jesus. How did I get this daughter? Thank you. We'll see you.